And then
Walking while black. I don't think so. Walking while black. I don't think so. You know, the world is against you. Don't let him be. Blake. Mr. Blake, you're charged with possession of marijuana. You're facing up to, you have to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On September 4th, 2024, officers were dispatched to a possession of marijuana investigation at 100 Hollows Tree Lane in Harris County, Texas. Officer was informed defendant crossed unauthorized crossing point from convenience store to apartment complex. Officer observed strong odor of marijuana.
Wait. He did what?
He says he crossed an unauthorized crossing point. So I guess he crossed the street.
Is he jaywalking?
Yeah. Yes, Your Honor. And then
walking while black.
And it says the officer observed a strong odor of marijuana, and he was informed that the defendant had begun to walk backwards upon being asked about marijuana by another officer. A PC search was conducted, and the officer observed.
Stop. That's a constitutional mic drop. The judge just said there is no probable cause. Crossing the street and walking backwards doesn't automatically equal a drug crime. The Fourth Amendment requires specific facts, not assumptions. That's the difference between a lawful stop and an unlawful search. Question for you: was this good police work or profiling that didn't hold up?
A large sack of.
I don't think so. Walking while black. I don't think so. I'm going to find no probable cause.
Yes,
Mr. Blake, be careful, man. You know, the world is against you. Don't let him be. Do something with your life. You know what I mean? The more you just, come on, man. All right, I'm going to have you just take a seat and back, all right? Hang tight. Well, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, man.
On September 4th, 2024, officers observed a defendant's vehicle failing to maintain a single lane at 2600 Eldridge Parkway in Harris County, Texas.
Notice the contrast here. No odor of alcohol, but swerving, slurred speech, failed field sobriety tests, and a refused blood draw. In court, it's called the totality of the circumstances. You don't need every box checked, just enough combined evidence to justify moving forward. Would you have refused the blood test, knowing a warrant could still be issued?
Officers observed the defendant's vehicle swerve on multiple occasions, cross over a center stripe lane divider, and on one occasion almost strike under the vehicle. Traffic stop was initiated. Officers made contact with the defendant, who was the driver of the vehicle. The officer observed lethargy, slurred speech. Defendant was read the DIC and refused blood. A blood search warrant was obtained and executed. Defendant was ID with a Texas driver's license.
Did you say there was an odor of alcohol as well, or no?
No, Your Honor.
Hey, Mr. Don't say anything.
I'm sorry.
Mr. Trevor, I'm going to find that there's probable cause to go forward with your case. Do you have a Texas driver license, ma'am?
Yes, sir.
Do you have valid liability insurance in your name?
Yes, sir.
Okay, I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You need to understand, if you're taking any kind of medication for depression or any other prescribed medication, controlled medication, it's still possible to abuse it, intoxicate, or make yourself, without the ability to drive. If you take too much, if you do something that you're not supposed to, you end up on the street again. I'm going to put you in jail. Do you understand that?
Yes, sir.
Does she have any prior DWIs?
I'll check, Your Honor.
If you can run her NCIC, please. How old are you, ma'am?
32.
What do you do for a living?
I'm a case manager for individuals with mental health and IDD.
Are you married? Children?
I have 2 kids. I'm not married yet.
You have 2 children?
Yes, 2 daughters, 11 and 4.
No previous DWI, just the previous theft.
Okay. Did you want to apply for an appointed lawyer, ma'am?
I can't afford it right now. I lost my job due to this incident.
I'm offering you a lawyer. Would you like a court-appointed lawyer, ma'am?
Yes, please.
I understand the stress about this, but don't abuse any kind of dope. Imagine if you go to jail and you don't have anyone to bond you out. Who's going to take care of those? Ma'am, Ms. Treadwell, I want you to listen. I know you're thinking about what to say, then you don't listen. If you go to...
I'm going to listen. Yes, sir.
If you go to jail and I can make your bond $15,000 and you don't have anyone to bond you out, who's going to take care of those 2 little girls? you need to consider this next time you're out there in the free world, because if I find that you're a danger, that you do something to violate these conditions, I'm going to put you in there. I'm not giving you any more PR bonds.
Yes, sir.
You understand?
Yes, sir.
Okay, I need you to fill out an application for me now. So deputy's going to give you an application. After that, I'm going to have you go to Victoria, sign a reset. You will eventually meet with Rachel for your bond conditions, and then we'll have you take your seat in the jury box. All right?
So,
Yeah. We'll direct you if you want to head that way. Okay, Yasha. Hey,
How are you?
what's going on?
Judge, I'm here on Mr. Tyrell. He has the bond violation.
Come up, Mr. Terrell. I'm sending you now for a drug test, sir.
Sir.
And then if you ever miss another drug test, I'm going to put you in jail, no questions asked, and I'm going to make your bond probably double what your felony is. Do you understand?
Sir,
As it stands, I ordered you not to consume alcohol or any kind of dope. We're going to test you now. We'll see what it shows, if anything. And then you have other things to do?
Yes, Judge.
You want to? Can you come back?
Yes.
Okay. Take a seat. You test positive for.
Sir,
Is that why you keep going? Man,
I stopped.
really?
Sir, I have.
This is where bond conditions become very real. When you're released pre-trial, it's conditional freedom, not a free pass. Testing positive while on bond for a felony? Judges see that as breaking trust. And legally, they can revoke bond immediately. But here's the human side. Is incarceration solving addiction or just pausing it?
For you to test positive, that means you probably did it within the last 2 days.
Sir,
Okay. I don't believe you.
I did it. I stopped doing it probably about a little bit under a week ago, probably like 4 days ago.
Yeah, okay.
But like, just being honest, sir,
He
I'm not
admits that
trying
he used, but he needs help, Judge.
I've
I'm
been
gonna
He's
get,
getting help.
and I'm going to give it to him.
I've been going into A meetings and stuff as well.
It's not working for you because you're still using. And I'm not going to take you coming here and telling me that I've quit. I'm going to stop. I told you that when you first got here. And that was the time when you start doing what you need to do. You now have shown me that you're incapable of stopping on your own. So I'm taking you in.
Sir.
It goes with you. No, you test positive for cocaine. You have an open felony case.
Judge, we can't put as a condition of his bond some sort of
I
treatment.
already did, Yasha.
Some help, at least, Judge.
Yeah, I'm gonna have him TRAS as soon as we get him back in there. And if they say inpatient treatment, boom. But what's his last name again?
Tyrell. But we can do the TRAS right now.
Yasha. If I don't take him into custody now, I'm telling him it's okay for him to do cocaine and that he's just gonna walk out of here. You think it'll ever stop? Really?
We can test him on Monday again.
He was out free and clear. He had the opportunity not to do it. He had the opportunity to clean himself. The only reason he's telling me now he wants to clean himself is because he's going in. That's the only reason, Yasha. Mr. Terrell, if you think that you're going to use cocaine and that you're going to walk out of here, it's just not going to happen. Goes with you.
Chance, please.
I already gave you a chance.
I'm a child, sir. I would just like one more
Then
chance.
if you're using cocaine out in the free world, you have no business having a child with you.
Do you think you could give me one more chance?
No, he goes with you. Sorry, Mr. Terrell. It's not gonna happen. Sorry. I can't let him go, man. I can't. I know, and I'm gonna give it to him now. Come up, Miss Bautista.
Go around the other way for me.
You are Jasmine Bautista. Miss Bautista, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with terroristic threat of a family or household member. On both of those, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews of the state of Texas. If you cannot afford a lawyer will be appointed to represent you. Okay.
Officer conducted follow-up investigation at 1505 Serpentine Drive, San Jacinto City in Harris County, Texas. Officer traveled to the residence and observed approximately a couple bullet holes, and the complaining witness advised that on August 25th at approximately 1:40 a.m., a dark-colored Dodge vehicle opened fire on the residence. No injuries were sustained. Complainant 1 advised that her brother's wife, later identified as the defendant, had recently made threats against the family. The complainant advised that her brother, complainant 2, and defendant had a fight on August 18th that escalated into a physical altercation. The complainant and other family members tried to separate them, and the defendant threatened to kill the entire family. Defendant threatened to have her brothers come and shoot all of them. The complainant, the defendant's husband, told officers that during the argument on August 18th, the defendant attacked him. Complainant advised that this was when the defendant threatened to have her brothers shoot and kill the entire family. Complainant believed the threat and fears for his life and his family's safety. Officer was given a video of the incident showing the defendant grabbing onto the complainant's leg and yelling, "You're all going to die, bitch, you and your fucking kids."
That statement, "you're gonna die," say that last statement again.
"You're all going to die, bitch, you and your fucking kids." I believe it was the defendant.
Zamaripa?
I believe. Because there's two complaining witnesses. There's the defendant's husband and then the defendant's husband's brother or sister, my apologies.
Okay, so it's a sister-in-law. So Ivan is the husband. Are you currently married to this person? Okay. Did I hear you say anything about the assault? What did you say about the assault? No, you were, that was just the terroristic threat.
In there, it says that there was a video of the defendant grabbing the complainant's leg. And then and there was also a physical altercation that they had to get involved in, separate them.
Okay, well, tell me about the assault. There has to be some kind of...
Can I have a response when he's done with that?
Absolutely.
Let me see if I can find the OR, Your Honor.
Sure. I have here, it says, on August 18th, 2024, the defendant, Jasmine Bautista, and the complainant were arguing and they were physically fighting. Raquel Zamaripa stated she saw the defendant scratching her brother. Raquel stated that she got involved to try to stop them from arguing and fighting, and that is when the defendant began screaming threats to her. The complainant and the other household members that she was going to have them all killed. The complainant statement, she believed the defendant could and would perform these threats.
Yes, Your Honor, there's that, and then when she grabbed the complainant's leg. So there's that first.
Now we've crossed into serious territory. A terroristic threat charge isn't about hurt feelings. It's about whether someone genuinely feared imminent harm. Add alleged gunfire days later, that dramatically raises the stakes. This isn't just family drama anymore. It's potential violent felony exposure. Where do you think the line is between emotional outburst and criminal threat?
Altercation where they had to intervene as well as whenever she grabbed the complainant's leg.
Okay, so let me just read this to you so that you also get this. It says, applicant spoke with Ivan Zamaripa, the complainant, on or about August 29th, 2024. At the Jacinto City Police Department, Ivan stated that he has dated and lives with the defendant, Jasmine, for about a year. He stated that on August 18th, he was having a verbal argument with the defendant as she did not want him spending so much time with his family members, and that the defendant hit him and scratched him and bit him. Complainant stated a couple of his family or household members began to try to separate the defendant from him. As this was going on, the defendant screamed that she was going to have her brothers come to the residence and shoot all of them and that they were all going to die. Complainant stated the defendant also stated that she said they were all going to die, even their kids. Complainant stated that he took the threat seriously and was in fear of his family's life. And as of the date his residence received gunshots on August 25th, 2024, he is in fear of his own serious imminent bodily injury. Complainant stated the defendant caused him and his family members to be in fear of their lives and serious imminent bodily injury. Complainant stated the defendant's assaults caused him pain and injuries. He showed photographs of his injuries from the night of August 18th, 2024. Affiant notes there were several fresh scratch marks on the complainant's back, chest, face, arm, and eye. Affiant also saw 3 fresh bite marks on the complainant. While she is sitting on the ground and the complainant is trying to get away, and I heard her screaming, you're all going to die, fuck your kids. Affiant looked up the defendant's driver's license number, yada yada, compared it to the video, and positively identified the defendant as Jasmine Bautista.
Yes.
What do you got?
Your Honor, the very same day that this happened, she went to the hospital for her injuries that were caused during this incident. She filed an assault charge. I think it's one of those situations where they file first. I have tons of pictures showing injuries all over her body. There were 6 people, family members of the defendant, that attacked my client at the house. They all attacked her, even the complaining witness on the assault here. Your Honor, if she grabbed her leg, I don't hear any statement that it caused her pain or anything to that degree that would make it a Class A misdemeanor. It seems
Here it
like it would have been
says-
appropriately filed as a Class C.
No. I mean, it says here, where does it says, where does it
Yes,
say?
Your Honor, the RIP was also performed as well.
Okay,
And it says that the complainant called the police because the defendant was threatening her brothers that she would kill the complainant's family. And then the defendant was biting the complaining witness, scratching the complaining witness, hitting the complaining witness, and spit on the complaining witness's face. And that's what was listed as far as the assault in the RIP call.
do we know if that are they still communicating? Do they want to have contact or no?
Ivan wants no contact.
Okay, I am gonna find that there's probable cause. Ms. Bautista, I'm ordering you as a condition of your bond not to have any contact with this person, not to be in possession of any weapons. I'm gonna tell you now, I will do everything in my power to protect the city. If I hear that there's more gunshots, any kind of drive-bys or anything like that, it's just not gonna go well. You're the one that's gonna end up going to jail. So just for now, cut ties, just go on. Do you have kids with this gentleman? Okay, it's wonderful. Just plenty of other fish in the sea. You know what I mean? Really, so many. Just please, there's a protective order in place. I would get to know it because if you violate the protective order, the state they will file additional charges against you, and then it's really going to go sideways. So please, no contact, no weapons. Okay. The protective order extends to him and to Raquel Zamaripa as well. Do you have any questions? So one more thing you need to understand is that the protective order limits you from going within 200 feet of where they live or where they work. So understand that you can't go over there. Even if he calls you and goes, hey, come on over, let's talk it out. I love you to death. Come on. No, if you go, you're still in violation, even if he were to ask you to go over there. So just, if he calls you, don't answer. Calls from an unknown number, hang up the phone. If he texts you, don't reply. Just, that's it. Give me questions. You have a great lawyer there. She will take care of you. She's junkyard dog right there. She really. So listen to her. She'll take care of you. I will waive your appearance, but you have to stay in touch with Ms. Sims, and she'll tell you when you have to come back to court. If she tells me she can't get a hold of you because you're playing games, I will issue a warrant for your arrest. You will not get any more PR bonds. I don't care what's going on there. You pick up a new case, you violate conditions, I'm gonna be one to bond you out. You'll be stuck like Chud. So be careful, man. Okay. So for now, I'm gonna have you sign a reset. Then we'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. Okay. Thanks.
Thank you, Your Honor.
Yesterday, came back for marijuana.
Yep. Come up, Mr. Osborne. Guys, what is all the times that we've had Mr. Osborne tested, times that he's been positive, times that he's been negative? How many times have we tested Mr. Osborne, please? It's nearly 400 days old and he's continuing to smoke weed. I mean,
This is the first time he's actually been tested, to my knowledge.
I don't think that's right. I think that we've tested him twice.
I understand he tested positive, Judge. My only concern is he is trying to get his degree, and I mean, obviously through his own doing, he's missed a lot of days of school, but I'm concerned that he's not.
Since December 21st of 23, he has had a dismissal offer where he's had to do 12 hours of community service, one class, and he gets his case dismissed. Now, a year later, we are still here and he's testing positive for marijuana.
only number I had for him was his mother's number, which is why he initially, and it got disconnected. I could not figure out how to contact him, which is why I had the PTI offer, but I couldn't reach him to give him the
It's
PTI.
not your fault, Mr. Schofield, and I'm not going to let you fall on the sword for him. But you're still smoking.
Only one judge.
Just the one today?
Yes.
We've never tested him before?
And we have a record now.
Where are we going?
He signed the PTI yesterday, so he's just got to get his community service and his anger management done.
What kind of anger management class are we talking?
Our anger management class, and he has 12 hours of community service.
You have 3 weeks to get everything done. If you don't have everything done in 3 weeks, you will get an immediate trial setting. This offer goes away. Do you understand, Mr. Osborne?
Yes, sir.
And the next time you test positive, I'm going to light you up. No more weed.
Sir.
How old are you?
18.
No more weed. Do you understand?
Sir.
You will get tested again. And if I find that you're continuing to smoke weed, into jail you will go. You have 3 weeks to get this thing done. That's it.
Thank you.
Hey. Hey.
Yeah. That's 3-1, Judge.
What's the last name?
Tomas Gonzalez.
This warning is bigger than it sounds. A DWI plea doesn't just affect your criminal record, it can trigger immigration consequences. Judges are required to advise defendants of that risk before accepting a plea. That moment right there, that's procedural protection. But imagine pleading guilty today and facing deportation tomorrow.
What page is it on? Is it on docket today?
Page 14, got it.
Yes.
Marcelino, okay. Mr. Marcelino Gonzalez, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor. You are facing a year in jail and/or a $4,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand that by pleading guilty to this offense, it will go on your record. It's going to be there for the rest of your natural born life. If you ever get pulled over in a car and you have an alcohol on your breath and the officer sees that you have a prior DWI, what do you think they're going to do to you? Right.
Yes.
What we're doing today, you will now be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand? And if you are not in this country with permission, you go to jail for that time. I can all but guarantee that you will get an immigration detainer. So if you have people that depend on you for whatever purpose, you going to jail for that kind of time completely wastes them. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you cannot change this. It will go on your record. It will be there until the day you die. Do you understand?
Yes.
Do you still want to do this?
Yes.
How do you plead to the offense of driving while intoxicated? I will find you guilty, sentence you to the 3 days in jail, give you credit for the 1. I'm going to suspend your license for 90 days. Do not drive until you get a license. Otherwise, you will be right back over here. Are you appointed on the case?
This is not, that's what she said.
Yeah, let me see some. Good luck to you, Mr. Marcelino.
What is the BCS?
3,000. Oh, it's 3,500. Good morning, ma'am.
Sir.
Ma'am, you're charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On October 15th, 2024, officers conducted a traffic stop on the.
We've already given.
Okay, everyone, all
I
right?
gave her one, and Victoria just gave her another one.
You first, sir.
Does it not work? Well, if it's not
Oh,
working, it's not working.
I'm not asking her to step on the
Okay, all right, sorry, Morgan.
Oh, okay. On October 15th, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it fail to signal a lane change and swerve left and right within its lane before striking the curb. Officers observed the defendant to be the sole occupant of the motor vehicle and detected an odor of alcohol and bloodshot, watery eyes on the person. Defendant admitted to drinking. SFSTs were conducted 6 out of 6 HGN, 5 out of 8 walk and turn, 3 out of 4 one-leg stand. DICs were read and defendant consented to breath test 0.163, 0.161.
Where was this?
It was east on Clear Lake City Boulevard.
Okay, all right. Because I'll explain to you later. All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol and kind of illegal drugs, I will put you in jail. You will not get any more PR bumps. Do you understand?
Yes, sir.
Do you have a Texas driver license?
Yes, sir.
Do you have valid liability insurance in your name?
I have regular insurance.
You have car insurance in
Yes,
your name?
sir.
Okay. We're going to reset your case to give you time to hire a lawyer. Don't sit and wait because you're only hurting yourself. You need to talk to a lawyer immediately because there's a lot of timing requirements. I'll have you sign a reset with Victoria. We'll have you meet with pretrial for your bond conditions, and after that, you're free to go.
Yes, sir.
Okay?
Thank you.
Please.
All right, Judge, next is case.
Good morning, Ms. Dixon. Ma'am, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one.
February 24th, 2024 at approximately 11:27 a.m. The officer did a license plate check on a vehicle that was shown to be registered to have active Class B warrants out of Montgomery County for driving while license invalid, and 6 Class C warrants from Humboldt Police Department. The registered owner was shown to be a Black female, and that female was seen driving the vehicle through the lower driver's side window, giving the officer reason to believe that the registered owner was currently driving that vehicle at the time. A traffic stop was initiated. The officer made contact with the defendant, who was identified by her Texas driver's license. The officer ran the defendant's information and showed that her license was ineligible and that she did not have any confirmed insurance. The Montgomery County Sheriff's Office and Humboldt PD confirmed the warrants.
Okay, can you run her license now?
Yes, Your Honor. It is not eligible right
And
now.
Ms. Dixon, I'm
Yes,
going to
sir.
find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to drive. I do not care what's going on in your life. If you do not have a Texas driver license and liability insurance in your name, you are not allowed to drive. If I find that you do, I will revoke your bond, put you in jail. Do you understand?
I have one question.
Stop. This is not the time for that. If you need, I can provide you a lawyer today, but this isn't where you just get to start asking questions, man. It's number one. Number two, this is a court. When you come to court, please dress appropriately, okay? So I'll have you go fill out an application with Miranda. I'm going to have you sign a receipt with Victoria. I'll have you take a seat in the jury box while we get your bond conditions, and then we'll have you speak to a lawyer in the material. Please. How's Jen? Really? It's good? Fun?
No, it's really not, but I'm blessed to be alive.
Well, that's a good attitude to have. That really is, because it could be a lot worse. You could always be 6 feet under, right?
Right.
Your lawyer is asking me to set you a bond, but I'm really concerned. This case is very old, and you've been out literally. She's been on the land for 10 years, Dave?
Well, the warrant was on November 9, 2015 for this one, Judge. but the surrender for the judgment roll was on, well, actually, the enrollment date was February 16th, but the surrender notice to file was April 2020. So I don't know what kind of efforts they went, but the actual forfeiture date was in 2015.
Do you know, do they really want, are they gonna
I
come?
mean, that's like with the other ones, I can only confirm the initial teletype confirming that the warrant is valid and they do still want her.
We've tried to reach out to, I'm sorry, Mr. Kim has tried to reach out to the demanding jurisdiction to see how serious of a case is it? Are they really gonna come back? But he's been unable to reach anyone. And I mean, it's only been, 30, 45 minutes. So, your lawyer's asking me to set you a bond. Because of the nature of the case, the type of case it is, and because of the age of the case, you're asking for.
Your Honor, the state's asking for $10,000 because it is a possession of controlled substance with intent for oxycodone and the fact that it's been in forfeiture status since 2015. This isn't one where it's a to-be warrant. It's one where she appeared in front of a judge, stated she would return, and then she didn't do that.
You want?
$1,500, Judge. My client has expressed to me that she is a college student. She has expressed to me that she only works for, because she's in school, Uber and DoorDash. She has expressed to me that she has an attorney that is working because she doesn't want this behind her. She can't have this when she graduates in May, if I'm not mistaken. I have explained to her the ramifications if this court was to give her the bond, that she has to that attorney either has to get her a date set there or she has to go turn herself in within the 14 days. She does not have any other criminal history or connection or otherwise, except for this one case from 2015.
The thing is that I have to set your bond sufficiently high so that you understand that we mean business. I'm not going to play this game with you again. If I set you a bond, it's only going to be one time. I won't do it again. You need to understand that there are serious consequences with the actions that you take now. I'm going to set you a bond. I'll set your bond at $5,000. And if and when you make bond, we give you 2 weeks from the date of your release to go turn yourself in to that jurisdiction where you're wanted from. Mr. Kim, where is it?
It's in Mississippi, Harrison County.
Go.
So you have to go turn yourself in. If you fail to do that, I will revoke this bond. I'm going to set it at 0. I will issue a nationwide warrant for your arrest. Obviously, I mean, you can't run forever, right? We're going to get you again. And this time I will physically hold you until Louisiana comes and gets you. Do you understand?
I do, Your Honor.
Okay.
So just knowing that, he has made the bond for $5,000, is that something that you or your family is able to post? Because if not,
5,000 cash?
It's 5,000.
Oh no, I have a deaf baby. I'm a single parent. My husband died 3.5 years ago. I'm on a fixed income. That's why I do DoorDash, and that's why I do Uber on the side just to help,
So I said that to say that the waiver, if he sets the bond, then the waiver goes away. They don't come and get you. You don't get to have the bond and wait for them at the same time and see which one happens first. So if you're not going to be able to pay the money, then you can, the option is to leave the waiver that you have in place that you signed on, I think 2/27, and then let them see if they're going to come get you or not. But your time, you don't lose the time that you've already been in custody.
So when you buy, I'm confused, when you behind,
What did she waive?
Right off that, 227?
February 27th.
So you have 1, 2, 3, 4, 5, 6 days credit. We give them 14 days to come get you. If they don't come get you within the 14 days, we release you. They file a dismissal, I sign it, and then they let you go. If that happens, the warrant will always remain active. And that warrant will always remain active until you physically go back or somehow go back to Louisiana and take care of it. That said, if you want to make this bond, you have to withdraw that waiver that you have, and then you lose those 6 days. So if you withdraw it and you don't make the bond, you lose all that time, and you basically it's told until you re-waive or you make that bond.
I only say this because of the age of the case and the fact that I didn't know she had counsel in Mississippi. It's very, very rare, but I have been seeing it happen here and there, is if local counsel there can get a new setting date. Like I said, it's incredibly rare. I can count on one hand the amount of times it's happened.
What do you mean, get a new setting date?
So even if they don't appear with sufficient evidence, from our sheriff's office that she's in our custody and her persons is here, and for a variety of factors, I can't speak to Mississippi because I'm not licensed there and I don't work there, is whatever sufficient factors they have to set a new date for her to self-surrender versus outside of the fugitive, they will recall the warrant. So like I said, it's incredibly rare, but only because of the age of the warrant and the fact that she has counsel there.
Well, but we don't know that.
Well, but I'm saying if the information for that counsel can be sent to.
I mean, I'm not going to give you a PR bond. This case is 10 years old. You've been I need you to understand that we mean business. I'm not here to play games. And so that's why we have to set it sufficiently high so that you realize that you have to have skin in the game so that we know that you're going to go back. I'll let you guys talk about it. I don't want you to make a decision here in front of everybody. So you guys talk about it. You know, I'm not stuck on the 5,000. I go back down a little bit, but it's not going to be much, you know, but.
I'll stand down. Thank you, Judge.
Sure. So,
Yeah.
So
Yes.
I'll let you guys go talk.
Okay.
I want you to say something here that you might invariably regret because it's in front of everyone, you know? Okay, please.
Thank you, Judge.
Thank you,
I'll
Judge.
go down some, you know, but a reasonable amount. All right. Mr. Lumumba, you are charged with 2 counts of driving while intoxicated. You've worked out an agreement. They're going to dismiss one in exchange for your plea on the other one. Pleading on 089. This one is, you know, they're all both 08. The agreement that you have is 180 days in jail to be probated for 15 months. As part of the agreement, you will do a DWI education class. You will do 3 victim impact panels, substance abuse treatment. You will also do what's called a TRAS. The TRAS is an evaluation to see what other conditions you may need. They will probably, because the fact that you have 2 open DWIs, they will probably add other conditions. It may be supportive outpatient treatment. It may be intensive outpatient treatment. I don't know. It may be inpatient. I have no idea. You must fulfill whatever other conditions they assess on you. No drugs, no alcohol. A guardian interlock. 25 hours of community service. Is this how you understand the agreement?
Yes, sir.
You need to understand that one of these will go on your record. The other one is going to be dismissed. But because of the fact that you have at least one of these going on your record, officers will always see this forever. It doesn't matter where you are, whether you're here, whether you're in Maryland, whether you're Alaska. And if you get pulled over, an officer, first thing they do is they run your license. They're going to see DWI car, and they smell alcohol on you. What do you think they're going to do?
Pull me out
Not just pull you out.
and breathalyze.
And what?
Arrest me.
Probably. I don't know for sure. But chances are they're going to see DWI. If they come up to you, they smell alcohol, it's probably not going to go well for you. So if I were you, even if you've had a sip of alcohol, don't get into a car because you're playing Russian roulette with your life. Do you understand?
Yes, Judge.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, you are done with this forever. You can never change this. Do you understand? This is what you want to do. How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will send it to the agreement. I'm not going to suspend your license because you're taking the probation today. I don't know what DPS is going to do. They may suspend it, they may not. So Do you know if his license is eligible now?
So Your Honor, it looks like he has a New Hampshire license, driver's license, but it does appear to be eligible out of New Hampshire.
Which one?
New Hampshire.
Anyway, so if your license is not valid at this point, you are not allowed to drive. You need to get permission from us. You're going to be signing an affidavit with us today promising us you're not.
This is the judge's philosophy laid bare. It's not about fines, it's about deterrence. First DWI might get probation. Second DWI, mandatory jail exposure, enhanced penalties, ignition interlocks. The system shifts from second chances to public protection fast. So here's the real question. How many chances should someone get before the court stops trusting them?
Going to drive. Do you understand?
Yes. You said it was?
It is eligible.
It is.
Oh, it is
It
eligible.
is, yes, Your Honor, it's eligible. It's an eligible New Hampshire driver's license.
Okay, as long as you have a valid license and you have liability insurance. So you must have car insurance. If you don't have car insurance, you're not allowed to drive. Do you understand? The other thing that you need is that if you're going to drive in whatever car you drive, you must have an interlock in it. Do you understand?
Yes, Judge.
So if I find that you don't have an interlock, it goes in lockout because you failed to pay for it. I'm going to issue a warrant for your arrest. If you don't remain in compliance with this, like you don't do your stuff on time, I'm going to issue a warrant for your arrest. If you're living in Maryland and I have to issue a warrant for your arrest and they pick you up in Maryland, holy moly, you're going to sit in jail for a very long time. So if you ever have any problems, you need to get in contact with Will. You need to get in contact with the Chatorium, because if not, and it goes into warrant status and you get picked up on it, you're going to be sitting for a long time. Do you understand?
Yes,
It
Judge.
takes forever in a day to extradite someone from another state to here. I mean, we're talking weeks. Do you understand? I'm not asking much. All I want my street safe. That's it. All right, how do you plead to the WI? Guilty or not guilty?
Guilty.
I'm going to find you guilty. Like I said, I'll follow the agreement. Your other case will be dismissed. Good luck to you, sir.
Thank you.
Are you working now? What are you doing with yourself?
I found about a main,
Okay.
and yeah,
You're working currently.
yeah.
Okay. It's never about the money. I could give a rat's ass about the money. I don't care about the money. I'm going to waive all your fees. Okay. I don't care about the money. But what I care about is public safety. I'm now taking off around probably, $6,000 in fines and fees off you now, Mr. Labuma.
Thank you, sir.
But if you pick up another DWI, if I see you pick up another DWI, from now on, you're facing not only a minimum of 30 days in jail, but a second DWI, it's a $6,000 surcharge. Get a clue. It's not hard. Good luck.
Thank you.
Thank you. We are done.